Hello, 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 hello. Hello, hello, hello. Hello, hello, hello. May I please, Your Lordship? I would like
Yes.
to mention item number 14. On consensus prayer, let the matter be fixed on 14th of August.
14th
14th of August, Your Lordship.
hearing matter.
Yes, Your Lordship.
It's 2014 19
Yes.
matter.
Yes, Your Lordship.
Any objection?
No, Lordship.
You are for respondent.
Respondent, Lordship.
What's your name?
I am Chen, Your Lordship. For the appellant.
Mr. I. M. Chen. Learned counsel for the appellant. Praise that matter may be listed
14th of August. Your
on
Lordship.
14th of August 2023. Mr. M.S. So-and-so learned counsel appearing on behalf of respondents.
Respondents, Your Lordship.
Respondent has no objection. List of, list this, prayer is allowed, list the matter on 14th,
Yes, Your Lordship.
8/2023.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I'd like to mention item number 15 and 17, Lordship.
15 and 17.
Lordship. On behalf of K. Angami, Lordship.
Okay,
Lordship, I pray that this matter come after 3 weeks, Lordship.
on the prayer of Mr.
K. Angami. K. Angami.
K. Angami, learned public prosecutor.
Lordship. PP.
List this matters on after 3 weeks.
After 3 weeks.
Mr. So-and-so appear on behalf of appellant.
Yes, madam.
Mr. So-and-so present on behalf of appellant. Item 15, 17,
17 also.
17 also, you are there?
Only 15, Lord.
Okay. 17, Senti young man. Have you taken the consent? 17?
Lordship, no.
Anyway, I'll see if there is an objection. Same prayer.
Lordship,
Same
I
order.
also have a prayer. Item number 16, Lordship. On
16,
behalf of E.T. Bapom.
E.T. Bapu. 16,
Yes, Lordship.
any consent?
No, Lordship.
Oh, Lordship. In fact, I thought we'll argue this matter today because if we have to exhaustively argue, some of the law points are yet to be decided,
Hmm.
but on limited points, it can be disposed of today. Anyways, tomorrow. Okay, Lordship.
Pass over. Pass over for
Tomorrow, what is the matter?
My Lord,
Do you,
PA to DC.
do you need to argue scholarly in this matter?
Yes, Lordship, in fact, I'm ready.
Tomorrow,
Lordship.
Okay.
we'll see tomorrow.
Okay.
On the prayer of the learned counsel for the parties. Let's this matter tomorrow for hearing. We'll see.
My Lord.
What is the issue?
The PA to DC without authority.
Regulation,
Yes, Lord.
regulation 31.
Yes, Lordship, under the rules for the administration of justice and police in Nagaland.
In that case, may not, you may,
It's very short matter.
you may not have to argue
Yes, Lordship,
scholarly.
my Lord,
We'll see tomorrow.
my Lord, bless you, Lordship.
Please, Your Lordship.
Yes,
Lordship, I'd like to mention number 8, Your Lordship, item number 8,
8.
on behalf of the council for the appellant, Vikram Debnath, Your Lordship. Lordship, I pray that this matter may come after 2 weeks, Your Lordship.
Then in that case, item 8 only
Item 8,
on the prayer of Mr. So-and-so. Learned counsel appearing on behalf of Mr. B. Debnath.
yes.
Learned counsel for the appellant. First, does this matter may be listed
After 2 weeks, Lordship.
after 2 weeks. Prayer is allowed, list after 2 weeks.
Lordship, similar prayer with item number 10, Lordship. Item number 10.
Similar prayer. Same order.
Item 10 and item number 13.
Okay.
13
13,
also, Your Worship. Yes.
13 rules.
Okay. Obliged, Your Worship.
No, this item 10 and 13, we'll see. It's for orders. We'll see after some time.
Lordship, the council is not present today, Your Worship.
You don't have the brief.
No, Lordship.
We'll see. It's in orders. 10 and 13, we'll see. Any objection?
No objection, Your Lordship.
In that case. Same order.
Lordship, petition item number 11, Lordship.
11.
Lordship, we have, last, with regard to the previous order, this court has, given instruction to file a paper publication to respond number 2 and 3. So we have, done the paper publication, but we're yet to file our affidavit, Your Lordship. So that 2 weeks may be given, Your Lordship.
Mr. So-and-so, you're for
For the appellant, Your Lordship.
appellant.
Yes. Plus, with regard to the previous order, this court has, given instruction to file a paper publication to
Mr. So-and-so learned counsel for the appellant submits that as per the order of this court, he has published the notice for service of respondent,
2 and 3.
respondent number 1,
2 and 3, Lordship.
Huh?
Respondent number 2 and 3.
respondent number 2 and 3. However, he could not file the affidavit regarding the publication. Therefore, phrase for some time to
Yes. 2 weeks.
file the affidavit. List the prayers allowed, list after 3 weeks.
Okay. Obliged, my lord.
Yes, Lordship. Lordship, I also like to mention item number 18, Lordship.
18.
Lordship, on behalf of my colleague Itibapom. 18. After a week, Lordship.
Mr. K. Angami, learned counsel,
Vijibon.
Vijimovi, sorry, learned counsel prays that this matter may be listed after 2 weeks.
Lordship.
Prayers allowed, list after 2 weeks.
Please, Lordship. Lordship, I'd like to mention item number 6.
Yes,
Lordship, I filed my vacant only this morning, Lordship.
okay.
So can you grant me 3 weeks time
For
to file my
Respondent.
affidavit in the possession?
Mr. So-and-so learned counsel submits that he has an instruction to appear in this matter for which he has filed the power today and press for some time to file reply.
Affidavit,
Affidavit,
Lordship.
affidavit in
Affidavit
opposition.
in possession.
Mr. So-and-so present for the learned counsel for the petitioner. Praise the Lord, list after 3 weeks.
Yes,
Lordship,
Lord.
there's an interim, if that can continue. Lordship.
Interim order passed earlier shall continue.
Much
Obliged,
obliged.
my lord.
Yes.
With your lordship. Lordship, this is a criminal appeal which has been filed against an impugned judgment and order dated 11/4/2023 by the special judge Foxco of Mon district.
You are for appellant,
I am for the appellant.
come this side. Where's
The
the,
appeal has been filed under section 374. But on the last date, this honorable court has pointed out about the maintainability of the appeal under 374.
yes,
So in this regard, I would like to submit before this honorable court to kindly convert it into a revision petition under section 397.
what is the judgment? Conversion judgment of this court? There's a judgment
Yeah, there
Of
is
this
a
court.
judgment of this,
that the appeal can be converted into revision. or revision can be
Yes.
converted into
I have
appeal.
a judgment passed by Justice Surana of Itanagar branch.
Are you appearing?
I'm not sure whether they have served the copy on.
The operating part is on page number 6. Point 16 and 3.
This was an appeal under section 372.
This was a, but if we go with a ratio,
Hmm?
for the interest of justice, then an appeal can be, if there is no particular provision in CRPC, then the appeal can be converted into a revision petition.
No, the easier is appeal. Has the appeal lies?
No, the appeal doesn't lie. The maintainability of the appeal is not, there is no particular provision. In my case, he has been convicted under section 354A
Correct.
and POCSO section 12. So
Section 12 or 14?
during the course of trial, he was under detention, and he was under detention for 13 months and few days. And while under section 354 and section 8 of POCSO, where under which he was charged initially, and he was not convicted on those particular sections. Later on the day of judgment, he was convicted under section 54A1 and section 12 of POCSO.
Let us see the sentence.
It is on page number 14.
Huh?
Page number 14.
14.
14.
1
to
4.
42.
Huh?
Page number 14 to 42. The order is on page number 41.
Ah. Jimobi? What do you say? Do you have the appeal?
Yes. Since I have received. the
He has
copy.
undergone more than 1 year,
1
And
year,
3 months.
to 1 month,
1
13
month,
months.
13 months.
13
This also says 1 year and 1 month, 13 months,
months.
and 3 weeks.
And 3 weeks.
Is he still in the jail?
No, he has been released. He has been released, but during the course of trial, he was under detention.
Hmm.
And after, on the day of judgment, under section 428, his conviction, he was convicted. At the same time, his period of detention was waived off and he was released after 13 months and 3 weeks.
So what remains there in that case?
But I was convicted.
Huh.
And I want to do away with that conviction, because I am an employee, and the consequences will be that I might lose my job because of this conviction.
Hmm. In that case, we'll see next week.
Lordship.
You go through the judgment.
Lordship.
First, we'll have to convert it.
Yes.
Admittedly, I think its appeal is not maintainable.
Not.
So, JJ, you share this judgment with your learned friend. We'll see the next week.
Lordship. Since I have received.
Or
the
should
copy
we convert it today?
Next week, Lordship, since I have to go through the petitions.
Okay.
The conversion can be given.
Next
Huh?
week.
It is up to your lordship to kindly convert the matter, because ultimately he will deal with he will oppose and
No.
deal with.
We'll have to
matter.
have a fair hearing.
Lordship.
We should give him a time.
Lordship, since I received the copy only today, so I'm not aware of.
Mr. A. Jimobi.
Jimobi.
B. Jimobi. Learned Counsel, learned public prosecutor of the state of Nagaland submits that since he has received the copy of the appeal petition this morning, he may be given some time to go through the same. As the matter relates to whether the present appeal can be converted into a revision petition, criminal revision petition, in view of the fact that the appeal seems to be not maintainable against the order passed by the trial court.
Lordship,
Uh,
date
prayer-
may be fixed.
Prayer not been objected to by learned counsel for the appellant. List this matter next
On
week
27. I come from Gauhati, so date may be fixed.
on 27th. List the matter on 27/7/2022.
Highly.
Compliant.
Lordship, my prayer is that the matter is now pending before the cabinet. So Lordship, can you draft 4 weeks time, Your Lordship?
No objection. Very fair. MS B. Sokri, learned counsel, learned additional advocate general. Press for 4 weeks time, as the matter is pending before the cabinet.
Yes, Lordship.
List of prayer not being objected to by the learned counsel for the petitioner. List this matter, prayers are allowed, list this matter after 4 weeks.
Much obliged.
Much obliged.
Item number 1 5. Lordship, here also the matters are pending before the cabinet. So same order may be passed, Your Lordship.
Same order but different counsel.
Yes, yes.
He may not readily agree.
No objection.
Okay, same order. But learned additional AJ, you have to be very serious about the contempt.
Yes, yes,
Which that
Lordship.
cannot allow to go
Yes,
like this.
yes, Lordship. So now the matter is before the cabinet.
Yes,
So
because
Yes.
once the order is passed,
yes,
you have the remedy.
Yes,
If you have
Lordship.
not availed that remedy,
yes,
you have to comply.
Lordship, Lordship. Much obliged.
In not in particular case, in all the
Yes,
cases.
yes, yes, Lordship.
There must be some sanctity to the order of the court.
True, true, Your Lordship.
Much.
Item number 7. Lordship here.
Complied.
Yes, Your Lordship.
Lordship, the matter may be closed.
Okay. Heard Mr. So-and-so, learned counsel to the petitioner. And also heard MS B. Chokri, learned additional advocate general of the state of Nagaland. Listen. Next para. MS B. Chokri, learned additional advocate general. Place the order of the government dated 2nd July 2023, whereby the petition
Lordship, it's 12th July, 12th.
12,
Yes,
okay,
yes.
12 July 2023. Whereby whereby in compliance of this court's order dated 3/07/2021, the service of the petitioner, namely Sri Sipongse Sangtam,
Lordship,
WC Kalasi, under executive engineer within bracket PhD, bracket close, Tuensang division, has been regularized. Christopher, next matter. In view of the above. No, please stop. Since the order of this court has been duly complied with. This contempt petition is closed.
Lordship, I am agreeing for respondent number one.
Okay, Mr. So appear for respondent number one.
One.
The copy of this next para, the copy, you just give his name after this hard so and so. The copy of the order dated 12th July 2020 be kept on record.
Much obliged, Lord.
Item number 9.
Lordship,
Yes.
Lordship, my senior physical photo is on his leg in port number 1 at present, Your Lordship. So operated this matter will be passed over for the time being, Lordship.
The what is to be done? You,
No, once-
you have sought for time to file reply affidavit.
Yeah, they
You
had-
have you filed the affidavit?
Yes, and they had already filed a reply also, Your Lordship.
Okay, so in that case, what should be done?
Yes, there is no contempt in this matter, Your Lordship.
Okay,
Yes, because we have.
what
also-
was the order?
The order was to,
What is the order?
Lordship, at page 13.
16 to 2022.
Yes, yes, and the operative part is at page 20.
Yes,
So.
just read it.
Page 7, para 7, the plea of the learned government advocate that the petitioner was not a regular employee at the time of his retirement and he was not entitled to regularization of his service under the OM such and such dated 17/3/2015. Therefore, he cannot enjoy the benefit of the amended rule cannot be accepted at this stage as that would amount to shifting the goalposts while the game is going on. From the reading of the entire record, these pleas were never taken by the respondent, and these are not the reason for denying the petitioner regularization of his service. Therefore, they cannot be accepted at this stage. In view of what has been stated above, this court is of the view that the opinion of the Finance Department and the decision of PHED given in the impugned orders are liable to be quashed and set aside. Accordingly, they are quashed and set aside. As in consequence, the respondents are hereby directed to consider the case of the petitioner afresh. The consideration and disposal of the matter should be done and completed within a period of 4 months from the date of receipt of a copy of this order. So, Your Lordship, this one is only to regularize, to consider his case for regularization.
Have you considered it?
No, Lordship, yes. Lordship, at page 10 of my affidavit of respondent number 2.
Affidavit. Yes.
Yes, then we have.
Monbemo Patan.
Lordship. Page
Is
10.
Is it by Sri E. Conbenos Patan? Your affidavit?
Yes, yes.
Yes.
Yes, Hambebo Patan.
Okay.
Yes, page 10, we have written to the petitioner.
He's the petitioner.
Yes.
Birenyu Chachu.
Yes. So Lordship, subject compliance of Honorable High Court Order dated 16/12/2022 passing such and such. As directed by the Honorable High Court by order dated 16/22 to consider your case afresh. The matter was put up to a PNAR department and the Finance Department for their opinion. The PNAR department, after examination, convened the following. The policy and scheme for regularization was already in existence by OM dated 22/9/2004. Forward charge employees before the retirement of the incumbent on 1/3/2012. The Public Health Engineering Department may therefore consider the regularization of the incumbent under the scheme within the 50% quota as per the office. C. The Public Health Engineering Department may examine the case in view of the above office memorandum. Number 2. The Finance Department held a meeting on 10/3/2023 to examine afresh the case of the petitioner and concluded that the petitioner was not holding a substantive post as stipulated under Rule 2 of the CCS pension rules and therefore does not fall within the ambit of this rule for grant of pension. that the undersigned have examined your case afresh as directed by the Honorable High Court and basing on the opinion of the PNAR Department and the findings of the Finance Department, would like to inform you that A, that as per OM dated 22/9/2004, work charge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior-most work charge employee in the relevant category will be regularized, subject to his or her fitness for the vacant post. That your seniority list was at serial number 457 among the work charge Kalasi at time of your retirement on 1/3/2012. And since you were not the senior-most in the relevant category at the time of your retirement, the department is unable to consider your regularization as per Office Memorandum 22/9/2004. B, the CCS pension rules are applicable only to those employees who are appointed against a substantive post and does not apply to work charge employees. That CCS pension rule 2B clearly provides that the rule shall not apply to person in casual and daily-rated employees. In view of the facts stated above, the department is unable to consider your regularization for pension benefits. So, Your Lordship, there is no contempt in the present case, and we have considered the case of the petitioner as per the court order, and accordingly, we have intimated to the petitioner on 14 March 2023.
What about this OM 17/3/2015
Lordship,
in the page 20 of the order,
20.
para 7?
Para 7, Your Lordship, this
Yeah,
is
his case will be guided by 2004.
four only, because he retires before the
He retired on 2012.
12, yes.
In the year
Lordship. So
2000.
OM 2015 does not apply to him, yes.
Okay.
So as per the OM 2004, regularization has to be made on the basis of seniority. So at the time of his retirement, he stands at serial number 457.
Mr. In that case, you'll have to file press petition if you
Yes,
are agreed by this consideration order. Prima facie, your case has been considered, and whatever may be the reason, you could not, your prayer could not be accepted. Specifically, the OM which regulates your service, according to them, is 2004. And you cannot, when you retire in 2012, you cannot, I think, thereafter claim the benefits of the OM, which was issued in 2015. More specifically, if it was not made retrospective effect. In that case, you file a press petition if you are agreed on its own merit. I don't think there's a contempt. She may be right. This court has directed the respondent authorities to consider your case. Though in the judgment, in the order, this court has not agreed to the submission of the learned counsel to the respondents. But then they have, wrongly or rightly, they have considered. So in that case, this court is of the view that, prima facie view that there is no contempt because consideration has been done. Either you withdraw it and will close it, you may approach, take the appropriate remedy if so advised.
So I have no instructions from my senior lordship so far. So
otherwise, your lordship contempt is between the court
Yes,
and
yes,
this.
yes.
So there is nothing to be pending, your lordship.
But problem is his senior is not here. After some time,
after some time.
Okay,
we'll
lordship.
see.
Lordship.
After some time, we'll see.
Okay, lordship.
Like,
Inform him.
oh, yes, he's got more.
We'll close it.
We have this Lordship.
Yes.
Lordship, this IA is for concerning a delay of 107 days.
Lordship, I have no objection.
You are for?
For the claimant respondent one and two.
Hmm?
Claimant respondent one and two.
Oh. Any other respondent?
This respondent number 3, Lordship. Await service report on respondent number 3.
Hmm?
Await service report on respondent number 3.
The notice has not been returned yet for respondent number two.
Is it?
Yes, Lordship.
You are for the claimant.
Yes, Lordship, one and two.
What is the, how many days of delay?
107 days, Lordship.
107.
7 days.
Okay. What is the ground of why it should be condemned? Hmm? Why it should be condoned?
Lordship, we have received the petition very late and then
Ah, what is the ground? This has been casually drafted, and then you come to page 5 of your petition, application. Para 10, you have not mentioned the, how many days of delay. Para 10. Second last line,
yes,
bottom.
107 days.
No, it's not written here. It's court's petition. 107.
Yes, Lordship.
It in the cause title is 149.
Yes, Lordship. I have made accounting mistakes and then I have rectified it.
Hmm?
I have made.
And in your prayer person also, you have not specifically mentioned the delay.
Yes, Your Lordship, that I have made a mistake.
Why you have
in
corrected it?
correcting,
First, you
Lordship,
have to correct in the copy of the court's
Lordship,
copy, but then
on that 29/3/23 order. In that order, I have rectified.
which order? By which order?
That 29/3/23.
No, you have mentioned that, but you have not corrected it. It was your submission that due to wrong calculation, it is 149 days. In fact, it should be 107. That was taken note of, but then it was supposed to be considered on today. Unless you correct this in the petition, how do we? It was not decided by this court whether your submission is correct or not. You file an appropriate petition for amending the IA. Is it? Is the thing, including a prayer person, you should first cause title, you said 149, 147. Your submission, you said 149. In para 10, it's kept blank. And para person, there is no mention of how many exact delay. You file an appropriate petition application for amendment of this your IA. Then we'll consider. Heard Mr. MS so-and-so learned counsel for the applicant, and also heard Mr. so-and-so learned counsel for the respondent number 1.
1 and 2, Lordship.
1 and 2. Office note indicates that office note that is 5/7/2023 indicates that the service notice for service upon respondent number 3 is still awaited. Please stop. Next para. It is noticed that by filing this IA, the applicant has prayed for condonation of prayed for condoning the delay of 149 days in filing the connected motor accident claim petition. However, according to the learned counsel for the applicant, it is 107 days in filing the connected appeal. On the perusal of the application, the delay of 149 days is mentioned only in the cause title. At para 10 of the application, the number of days has been kept blank. Moreover, there is no mention of number of days in the prior portion. In view of the above, this court finds it difficult to consider the application in its present form. Please stop. Next para. The learned counsel for the applicant is directed to file appropriate application for appropriate application for correction of the above referred mistakes. List this matter after 2 weeks. It's so casually drafted and casually you have not taken it. And you have not, I think, read the order of this court of 29(3). Have you read it? This court has taken note of your submission only. And last second para, it says it will be considered at the time of disposal. There's a reason of saying so, because your submission could not have been accepted as it is. So kindly next time read the court's order properly. Okay. Still busy?
Still busy, Lordship. Sir,
What to do?
Lordship, I pray that this matter will come up tomorrow, Lordship.
In that case, next week or tomorrow?
Tomorrow or next week, anything, Lordship.
Tomorrow is a hearing day or what? Okay, tomorrow.
Okay.
On the prayer of Mr. So-and-so, learned counsel, list this matter on 18/7/2023.
Deep obliged, man of
No, sir,
Computer section, court 2/.